Michelle, you are elected.
Oh.
Okay. Jeff, are we ready? Okay. This is George Finder, and we are going to go through the diagnostic quiz with some of our audience, and we are going to see what the answers are, and we're going to start with this. I'm not going to use names, by the way, okay? And we're going to start with the first question. You want to read it?
Credit damage has been recognized as a form of reputation damage.
Is that true or false?
True.
That is true. Okay. Do I need to explain why? I think it's pretty self-evident. Question number 2.
Credit damage measurement is different from the service of an economist.
True
True.
or false? Okay. Do you know why?
Because an economist is looking at the means of the flow of money, and the credit damage is the lack of.
Well, okay. That's as good of an answer as any, and I'm just going to go with it. How's that? An economist does not do what I do or what a credit damage assessor would do, or an economist has a very definite set of sources from which they pull information, which is as often as not the Bureau of Labor and Statistics, lots of tables, and then they have all sorts of formulas which they apply to that information and arrive at their opinion. I don't do either one of those. A credit damage assessor would not do either one of those, and would only limit their services to credit issues, not to any other issues. Okay, Michelle, I'm sorry.
Credit damage measurement is based on credit industry documentation. And false.
What else would you base it on?
I wasn't sure
Well,
as to
if you're going
how it's
to
measured.
prepare documents related to the credit industry, the most reliable documents you could possibly use would be monthly statements, would be credit reports, would be any of those kinds of documents, notices that are routinely used within the industry to achieve whatever their goals are. And our purpose is to use those documents to establish the before and after status of the okay?
Credit damage may be included with other damage demand aspects. I'm a bit compromised, but I think it's true that it may
Overlap, it's facets of a gem. Medical damages are part of a damage demand. Economic damages are part of a damage demand. Medical damages are part of a damage demand. So if you're going to include credit damage, where else would you put it other than your damage demand? Yes?
Yes.
Okay, Tom?
Right.
Okay.
That's good.
Identification of credit damage victims began at the intake meeting. I wrote false, but I'm not positive because I wasn't sure what intake really means. Intake meeting. I'm not familiar with that word or that.
The intake meeting, as I understand it to be used, is that when a law office has decided to gather information relevant to the acceptance or denial of a case, they intake information. And where that is done or where that information is reviewed in a concentrated activity, I refer to as an intake meeting. It could be a telephone call where someone calls up the law office and says, I need your help, and the lawyer or the paralegal says, tell me what's going on. That is not an intake meeting, but it can be an intake moment okay, or event, I consider an intake meeting as the first step of developing a case. The preliminary considerations have been satisfied, and the law office says, let's pursue this puppy. Is that fair to say, Tom? Okay.
The point is to elevate that process. You're going to have to take it seriously and formally, in a sense.
It does formalize it. It also puts credit damage on a par with all the other aspects of the case. If, as an example, a personal injury case, sufficient time has passed that medical bills have accumulated as part of the intake meeting, medical bills would be evaluated. If there's property damage, the repairs are collected and are considered as part of the damage demand. Same thing with loss of income. The intake meeting starts that process. The pursuit of the case, I'm sure that's not the right language, follows that intake meeting and to its ultimate conclusion, which is resolution of the matter. Yes?
Yes. Credit damage may be a unique damage and a cause of action. False.
No, let them answer. You
Oh.
know the answers.
That's because it is not its own cause of action. It is damage. And you don't need to look for, an intentional infliction of credit damage. No. It's part of whatever wrongful act you can find that's appropriate to allege.
I'm going to change the format just a little bit for question 7. The question is, credit damages may not be included in which of the following types of cases? I'm going to read them all, then I'm going to ask each of you which is not included. And what I'm reading, other than the one type of action which is excluded, all the other ones are acceptable, or accepted as including credit damage. That would include fraud, malpractice, lender reporting errors, workman's compensation cases, divorce, identity theft, breach of contract, bill collection violations, wrongful termination, self-inflicted damage, credit report errors, and immigration. So, my plaid friend, which of these do you think are not to be included?
Self-inflicted damage,
Is that the only one?
immigration.
Anything else?
I think divorce, when you're doing a division of assets and debts,
Would not be included or would?
it would not be included.
We disagree.
That's a damage.
We disagree.
Well, she's saying as damage.
Tom, explain it to her.
We've worked very hard on credit damage in divorce. The point is that it could involve damages because one party might breach their fiduciary duty to avoid, in divorce, every partner has a very high duty to avoid benefiting themselves at the expense of their partner. And invariably, if they have separate credit, they invariably have joint credit as well. At the time of divorce, they stop the joint, and invariably, there isn't a equalization of the two. And so now you have, the oppression, the fraud, the possibility of that being deliberate, or is a breach of fiduciary duty enough? That already is, because of the high duty, possibly enough for damages. Under 1101 type damages, the teeth in the fiduciary duty.
I think you would find it harder to to separate it out in most situations. Here you're looking at egregious divorces versus the ordinary divorce.
It is, and the main use of a credit damage, or excuse me, a credit assessor would be, in a divorce, would be just to measure how much the equalization should be. Typically, the husband walks off with good credit and the wife walks off with the removal of her biggest asset and a dramatic decline in the value of her credit. So should the husband give an equalization to the wife? How would you measure how big that is? You'd need an assessor, or it'd be appropriate to have an assessor.
So then it becomes an offsetting value.
Yes,
To offset the inequality of their positions.
it would be called the equalization payment. But you're right, it's not quite damages in the same, in that set.
Okay, moving on.
So what's the answer?
They're all right. Immigration is not a credit-related issue,
Well, self-inflicted damage.
and self-inflicted damage is not a compensable issue. Okay? So all of those are,
Immigration and self-inflicted.
yes, would be excluded.
Wouldn't you also encounter a problem with a breach of contract if it wasn't one of the terms of the contract?
Well, in California, the Civil Code says the measure of damages, if it can be ascertained and measured and it's certain, you're entitled to the detriment caused by the breach. You have a right to breach, but the breacher has the duty of paying compensation for that breach. And this form of damages would certainly be covered in the foreseeable outcome of a breach. So in contract, foreseeability is required. In tort, it is not, typically. But in contract, if it's foreseeable, and we would argue that it could be foreseeable that somebody would, as a result of a breach, if I promised to pay you and I didn't pay you, but you were counting on the payment to pay your house payment, and I knew that, then it's foreseeable to me, so that when I breached, I'd have to pay the damage of your credit having been dinged because you didn't have the money that I promised to give you.
I see, thank you.
And by the way, what he just said is lawyer service, not credit damage assessor service. He is advocating the reason for its acceptability, not the service that the credit damage assessor would provide. Okay? I
Right.
want to be clear on that.
The assessor isn't making that argument.
Right, okay? Credit damage assessors are not advocates. They are neutral parties. Very important not to be an advocate for anything other than the facts in the case. Let's talk about credit damage valuation services include credit repair type services. Is that true or false?
Based
Michelle.
on what you just said, I think that would be false. What do you think?
I'm kind of torn between the two.
Why are you torn?
Well, I think that, gosh, the valuation services, no, I'll say true.
No.
Well, the evaluation
Valuating-
service evaluates a fact, and the repair type service is a fix-it.
We don't fix anything,
Okay, so that would be false.
okay?
Now let's explain though.
Go ahead.
There may be a role for a credit repair person. I mean, that may be a service that is needed by many people. It is outside the assessment of measuring what a reputation loss is.
And the analogy I like to use is a doctor versus a brain surgeon versus a obstetrician. They're both doctors, but they both have special functions. A credit damage assessor is not taught to do credit repair in the context of the information that we're providing.
Yeah.
Okay?
So the specialist.
Somebody else. In my opinion, that's why Tom and I agreed not to include any of the skills required for a credit repair type service in what we're presenting.
Also, that would put the assessor into the role of being an advocate, in a sense. So kind of an ethical concern that you're measuring something. You're not urging anyone to do something to that. In other words, you accept the fact that the Credit Reporting Bureau has given it this score. You're not, struggling to change that. You have no duty to, and that would change the situation.
Right.
Okay.
Do you want to read the next one?
Credit damage valuation services may be provided by consultation or expert retainer.
Rita?
I think that's true because you're identifying the facts here and taking a measurement. And that would be a fact that you could do as a consult,
Yes?
just by identification of the fact existing, or as an expert, you're there to giving credit to that. And again, identifying that fact existing.
Right.
In this profession, you can make money by being a consultant, just to help people determine whether or not they were injured or how much their injury is. Should it be pursued further? Or you can be retained and testify in court. You don't need to, it's not all or nothing.
It is, I think, safe to say that attorneys need guidance regarding credit damage issues in a case. That could be provided as a consultation without the restrictions and requirements of being a designated expert witness. So, of course, it would be true.
I see. Thank you.
Okay. Credit valuation services are provided only to plaintiff counsel. True or false?
That would be false.
Good.
Both.
We are equal opportunity, neutral opinion providers.
Here again, the facts either prove or disprove something, and so you've identified or quantified something existing or not existing.
Bingo. There
Now, George, do you get retained by defendants?
Defense counsel, yes. I believe in equal opportunities, in being an equal opportunity server. I believe that defense has the right to the same skills as the plaintiff does, in the sense of a credit damage evaluator or assessor. And while the facts of the case may be the same, there are differences. I stated earlier, I don't know if you were here yet or not, that of approximately 1,000 cases that are filed in which credit damage is included in the demand, approximately 3 are recognized and receive compensation. One of the reasons for that is because the understanding and ability of the attorney to prepare, either by themselves or to find an expert to prepare an appropriate report as the basis or foundation for a credit damage claim or demand, the attorney doesn't have that ability. Either don't know where to look or don't want to look, or just throw it in the boilerplate and hope something catches. I had lunch a couple months ago with an arbitrator who said to me that every time she sees a credit damage demand that's part of her petition or whatever the form is called, she throws it out. Routinely, she says, show me the foundation of including credit damage in this demand, and I will accept it. The attorneys don't know how to do it. So one of the differences in working for defense versus working for a plaintiff is to help the defense force the plaintiff's attorney to prepare a proper credit damage valuation vigorously or have it thrown out. Not let it slip through. Okay?
Thank you. It kind of clarifies it whether or not they actually understood what they were doing and they weren't just building a smoke screen.
Some try to.
A lot of claims of damage are speculative, wishful thinking, unascertainable, not proven. In other words, how do you prove something? You use documents or witnesses. And expertise, this is an area that helps a great deal. Where are we?
Well,
An aspect of credit damage valuation may be increased out-of-pocket cost. That would be increased out-of-pocket cost of credit.
yes.
And give us an example.
Credit cards increase the interest rate, which changes the monthly payment on their credit card. That's an increased out-of-pocket cost.
And so that increment every month is the result of a wrongful act. It could be recovered.
Exactly.
Great. So the victim isn't getting anything more than the difference between what life was before and after the wrongful act. And that's what they're compensated for, and that's what they're entitled to.
An aspect of credit damage valuation may be the loss of credit capacity. Michelle, do you, yes or no?
Or put true.
Why?
Well, a lot of the stuff I'm just guessing, really.
That's why I asked you why, because I knew you were guessing.
Here again, you look at the wife who lost the ability to have credit, or because you don't have certain benefits to your credit resume, you don't qualify as a person with enough ability to go forth and get that credit. You've lost the ability.
To maintain it, correct. And as a result of not maintaining it, it is withdrawn.
Right.
Okay? And it's withdrawn either by cancellation, and if there's a balance owing, which we will assume there is, the ripple effect or the consequential effect is collection accounts. Okay? Now, credit capacity can also be changed by changing the amount of the line of credit. Let's assume that prior to the injury you had credit cards totaling $10,000. You keep your payments up. You're a little late on your payments, but you make them. If they're due on the 1st, you make them on the 10th. You're paying the late charges, but you're paying them, okay? And the credit card company says, we reviewed your credit report or your payment habits and your account, and we have determined that we are adjusting, or that your new credit line will be $5,000. They will not tell you we're cutting off $5,000. They'll simply tell you your new credit line is $5,000, and everybody knows what their credit limit is. And when you realize that your credit limit has gone from $10,000 to $5,000, you have lost credit capacity. Okay?
Now, what's the difference between credit capacity and credit expectancy?
Expectancy is the ability to get new credit, and credit capacity is credit you've already been granted.
As in this first example.
Yes.
Great.
Okay. Now, there's another corollary to this issue, and that is if the credit card company want you to keep paying the bill, and you're making the payments, and again, whether you're late or whether you're on time is not a major concern for them, but they're starting to get nervous. They will lower your credit limit to the balance owed. So if you had $3,000 debt against a $10,000 credit limit, you will get a notice, typically with your monthly statement, that says your new credit limit is $3,000. And when you pay the current month's payment, which would lower your debt to $2,900 instead of $3,000, you will get a notice that says your new credit limit is $2,900. Your credit has been terminated, but you still have an active account. So how does that reflect in your credit report? These are one of the imponderables that a credit damage assessor will learn how to analyze and interpret.
So anything that affects you negatively is something that's really a credit damage.
I think so.
That's it. It has to damage you. There are wrongful acts that result in benefits to the victim. I mean, somebody just inadvertently tried to hurt you, and they ended up helping you. I mean, that happens all the time. It happens with credit.
Really? I've never heard of that. Go ahead. Number 13. Read it anyway.
13. An aspect of credit damage valuation may be loss of credit expectancy.
Okay. Michelle?
Definitely, I think that's true.
Okay, why?
Because, just like you mentioned before, if you had a substantial amount of credit and then they reduce it.
How about if they took away your credit, or they
Right.
didn't take away your credit, but you want more credit? Whatever amount of credit you have, right now you want more. And based on your pattern of behavior in the past, when you applied for credit, you got it. So you expect to be able to get credit again, because you are a responsible person who makes their payments on time. All right? Well, something has happened, and whether you still have your credit accounts or you don't, you want more. And you apply for some sort of credit with the expectancy, based on your own personal history, that you will be approved for a gasoline card or a department store card or something like that. You get denied. That is loss of expectancy. And you don't get denied just once, although that's sufficient. What if you say, well, that's a fluke. I didn't get a Shell Oil card. I'll apply to Valero, because you expect to be approved. And you get turned down. You say, whoa, something is wrong here. I'm going to apply to Chevron, because they love everybody, okay? I'm breathing, I've got a job, I'll get a Chevron credit card. And you apply, and you get turned down. That is loss of expectancy. And the loss of expectancy is evidenced by you stop applying, because you've realized that your expectation of being approved is unrealistic. You've lost that expectancy of approval.
Can it lower your FICO score if you apply and keep applying for these things?
Yes. And please don't refer to it as a FICO score, it's a credit score.
Oh, it's a credit score.
FICO score is a brand name. I don't want to endorse anybody's brand.
For the record, my prediction is that's exactly what's happened. They can't help it.
What's
It'll be
that?
like Kleenex.
Oh, I agree with you, but I don't want to contribute to the problem. All right, let's go to
An aspect of credit damage measurement report is monetized damages on a yearly basis.
now, you were both here when we talked about that. Does anybody remember what was said?
Oh, this is a tough one.
This is a tough one.
It's on a month basis, isn't it? No. Oops.
Remember, you have a 7-year period during which the damage can exist. But let's assume, for whatever reason, that it's a shorter term than 7 years. Okay? That it's only going to be a 3-year period. Let's hypothecate that the damage was caused by the improper appearance of 3 late payments on your mortgage account. And you decide, whoa, that's not right. Somebody messed up, the credit report is wrong. Your attorney says, wow, you've got documentation. Your credit report accuracy is being violated. The FCRA is being violated. Let's get that record straightened out. So the period during which this inaccurate information appears on the credit report is 2 years. That's the duration of the damage period. Because as soon as they remove that inappropriate record from your credit report, the harm should stop, because that remark or those remarks no longer appear in your credit report. So you wouldn't go for a 7-year damage, you'd go for the damage period.
Yeah.
Okay?
Good. 16 is a credit damage measurement report includes minimum monetized credit damage value. True or false?
Read it.
I think that's true because it has to give you a report of where your condition is today.
Yes.
Okay, any discussion or you want
No.
feedback?
Michelle, are you comfortable with what it says, or do you want clarification?
I'm just not familiarized with all the terminology and everything. I'm trying to wrap my brain around it all.
That's why this will be recorded. Go ahead. What's the question?
Well, I'm not familiar with the credit damage measurement report, but we just did a few things you just explained a few things that helps me understand it a little bit more.
Yes.
But since this is really new to me, I'm not really sure as to what is minimum monetized credit damage value. Can you
The purpose.
explain
yes.
that?
The purpose of the credit damage report is not just to confirm that the damage happened. There are many experts who will not be considered credit damage assessors who will say, yes, there are 3 late payments in the client's credit report that shouldn't be there. That's my opinion, that's my testimony, I'm not saying another word. That's not an assessment of the damage. There is a value, we will assume for the simplicity of this example, that while that only appeared on the record for 3 months, as a result of that, they lost the opportunity for a loan modification. They lost a job, either getting one or a promotion of one. And it can be established that those injuries happened as a result of improper information appearing in the credit report.
And literally, you may be looking at documents where a letter is written canceling credit.
Absolutely.
Within that 3-year period, as a result of something.
3-month period.
3
Yes. All of those bad things can happen. Well, my opinion is if you don't monetize it, what's the point? The point of tort is compensation.
And the word monetize and liquidate, ascertain, these are just ways of describing that process of measuring the difference between the before and after the wrongful act.
Okay? So I'm glad you asked that
So
question.
monetizing is making it a number, which is the useful thing to do here.
What we are trying to do is provide the offending party, the responsible party, a number that they can write a check for.
By the way, in this case, this is the first class. You haven't really had the class on monetizing yet. But be assured that we're just talking about mathematics. We're just adding up a number of losses or impacts. on the-
As an example, if as a result of the 3-month late payments appearing in the credit report for, we'll say that they appeared for a year. There were only 3 late payments being reported, but they reported for a year. As a result of that, problems happened. That's what we want to compensate the victim for. If we can, and our purpose, our requirement is to, with proper foundation, present to the parties that need to know what those damages are and what the financial, economic, money, dollar impact on the lives of those people or those individuals was, because our purpose is to bring them back to where they should have been but for that injury. Okay? Michelle?
Yep.
I'm
So
trying to
that
fill-
injury stays in effect again, that 2-year period that you discussed previously. Is that what you're saying?
No,
That
I-
1 3-month?
No, if the injury appears, if 3 months of late payments, we'll assume that they're consecutive 3 payments that are late, if those appear in a credit report for 1 year, if during that 1-year period, the harm caused or the damage caused to the plaintiff is cancellation of credit, increased borrowing costs, or the inability to get new credit to replace canceled credit or just because they want more credit, that's the damage that needs to be valued for 1 year, because when the statements, when the remarks, the improper remarks are removed, no more damage is being done. The remarks aren't there to cause the damage, but they were there for 1 year. And in that 1-year period, these are the detriments, these are the damages that were experienced by the plaintiff, and we can prove that through documents. Okay?
Okay, thank you.
So is it limited to just 1 year, or can it be measured at, say, 5-year period?
It's however the information, however long the information appears to cause the damage. When the information evaporates, disappears, is obfuscated, is no longer there for a reviewer of the credit report to be aware of, there's no more damage.
It's not going to be longer than 7. It might be shorter. You may have facts that end it because the correction was made and there were no consequences.
Okay? I want to make sure you understand that. Okay?
It's time consuming to go through and add up what is the damage caused where you have increased interest rates and increased down payment, higher installments. But you can add these up and then present them.
And that's what I do in my report, by the way. My credit damage measurement report or my credit damage analysis report.
And again, it's just the mathematics of going through the records and pulling these numbers out in an organized fashion so that you can testify about it, which brings us to the next one. Results or opinions of the case may be provided in a written or verbal report.
Michelle?
I'm going to say true.
Good. Do you know why?
I'm guessing the results of the case would be, the written part would, I'm guessing it's the credit report, and the verbal would be the assessor giving their opinion. That's
Okay, but the reason that it can be verbal or written is some lawyers do not want a written report because it becomes discoverable.
Oh.
Okay?
So there's real ranges here. You can provide a service, but don't think it's always going to be written.
And one of the things what we will include in our presentation education is how to protect yourself from somebody coming back and saying, you didn't deliver the services I contracted with you for. Where's the report that you were going to give me? Well, I gave you an oral report. Well, I never got it. If you keep appropriate notes and records, you will overcome that claim. And it will make your life much, much easier.
And document the fact of the work that you did.
Documents you reviewed. Go ahead, I'm sorry.
18 is a line of credit or credit account is debt. True or false?
That's true.
False.
I think it's false because it's not debt until you've used it. It's available, but doesn't become a real debt until you've gone ahead and
You know, it's
accepted
even,
and used it.
yeah, you've used it, but because it's credit, you could even, you understand that this is a deferred obligation. So it's that deferment. Remember we talked about the time quality. It is a debt, but is it really a debt until the date it's due?
But let me define that a little differently for you, okay? I go to the bank. I get a home equity line of credit secured by property. And to make things simple, it's a $100,000 line of credit. The lender has said, you can have $100,000 anytime you want, in any amount you want, as long as it doesn't exceed $100,000. That is your line of credit. There is no obligation to repay it, because there is no debt. There is no usage. There is no due date.
Yeah.
When you pull the first dollar out, then it becomes debt.
Well,
And then it has a obligation for repayment due date.
right. It's certainly on the debt side of your, it's not an asset any longer, but keep in mind that it's still a payable and not an obligation that you have to pay.
It's
The
the way,
deferment is part of it.
there is no deferment, because until you use it, there's no obligation. You have a recognition.
No, I'm talking about the part you borrowed.
Oh, yes, absolutely, I'm sorry.
Have to watch you carefully.
Very careful.
But you're exactly right. The line of credit is an asset. When you pull something out of it, it's still not quite, you know, it's so different than a debt still, because it's still deferred. It's a debt on the date due. You know, so it's a payable. So credit is not complicated. It's,
Well, one of the things we haven't touched on, it looks to me like we have about 10 minutes, is that about right? Okay. There are two kinds of debt. There is revolving debt, which is best known as a credit card.
is that the same as rolling?
Yes,
Rolling or revolving debt?
right. And the other is amortized or structured debt. Amortized debt is best known as a mortgage. It has a fixed period, it has a fixed payment schedule, it has a fixed or adjustable, but it has a predictable interest or cost factor in the contract from day one. A rolling debt or revolving debt, again, most typically a credit card, you still have a line of credit. Let's assume that your credit limit on your credit card is $10,000. You can use up to $10,000, and as long as you make the required or requested minimum monthly payment on that account every month, you could keep a $10,000 balance less the monthly payment for the rest of your life. There is no payoff date because it's a revolving or rolling debt. So there is no termination. So I just want to spell out that that's the
Two
two.
different
Yes.
types of credit.
Yes.
And number 19, consumer credit reports are on a single person or entity. On a single person or entity.
They can be married though.
So can a corporation have credit? An entity certainly can.
but not a consumer credit report.
And can a corporation suffer credit injury? And is it possible to have joint credit?
It is possible to have joint credit, but not a joint credit report
By law.
by law.
Now, in other words, each of the partners in the joint relationship are entitled to a credit report. And they're entitled to credit by law. Now,
Well,
if they're not married, can you have joint?
well, there is no such thing as a joint credit report. There's a merged credit report, okay, where you take two individuals, married or not, who have a permissible reason to get involved in an account, whether it's a mortgage or a credit card or a savings account or
Could
checking
be
account.
a commercial partnership.
Could be a commercial partnership, okay? And commercial partnerships would not have a consumer credit report. They would have a business credit report. A husband and wife, mother and daughter, father and son, or any of those human relationships could have joint credit, could have merged credit, but they, by law, must each have their individual credit report. A credit report can only be about one person. It cannot be about you and your brother, it cannot be about your loved one of any kind, it can only be about you. Okay?
Any questions? And 20, only a subscriber type of consumer credit report is accepted by lenders or employers. Now here the question is subscriber type of consumer credit report, as opposed to what type?
Consumer disclosure. Non-subscriber.
Yeah,
Okay?
I wouldn't have put consumer credit report here, but
But it's on an individual, it's not a business. That's
only
the
a
difference.
subscriber type of consumer credit report is accepted by lenders.
And employers.
True or false?
Michelle, I'm going to pick on you again.
Well,
I'm gonna say false, but I don't know why though. I want
Why?
that explained.
Okay? A subscriber credit report is, by experience, the most accurate, reliable credit report available to lenders and employers. It is much more accurate than a consumer disclosure report or a free report.
now let's spell that out. The consumer disclosure report is the one you get for free. The subscriber report is the one you can't get as a consumer, but the subscriber will get it on your data. Now this, I don't mean to sound like this is unfair at all. This is perfectly, appropriate business, but you're clearly not entitled by any law to get the proprietary the results of the algorithms and data that they have collected on you.
Right?
So,
In other words, you're talking about the interpretation of the data that comes along with this, with
No one-
subscriber
no,
type.
no.
the data itself is proprietary to them. If they collected it, there's nothing that they have that's yours, but it's all yours.
It's all about you, but it's not yours.
It's all.
Okay? And Tom, I think, has a discomfort with the phrase consumer credit report. Consumer credit report only means that it's on an individual rather than a business. The individual is referred to as a consumer for legal purposes. Okay? The subscriber report is a business tool on those individuals. The credit bureaus, in their cleverness, have decided to sell a different kind of credit report to the consumer about themselves, all perfectly legal, but experience has shown us that the subscriber report has more information and has fewer errors and omissions than the consumer credit report that is in plain English. So if I were going to build an opinion on the strongest possible foundation, I would not use a consumer credit report that was not a subscriber consumer credit report.
Now, as an expert witness, are you able to get your hands on the subscriber report?
As a clever Hungarian individual, yes, I am.
And you base your opinion then on this better type of report that's more accurate?
It's not that it's better, it's that it's the only source of information on which a lender will rely in the form of a credit report.
That's it. This is the one that counts.
This is the one that counts.
Good.
Anything else is irrelevant, because if the lender did not base their opinion on it, how can you claim that it's the cause of damage?
So are you talking about the TRW, Experian, and when you say subscriber, is that what you mean?
No, TRW is a company that no longer exists.
Okay.
It is now replaced by Experian.
Okay.
TransUnion is a company that issues a report on consumers. Equifax issues a report, or is the report issued by the CBI company, CBI Inc. Okay?
Summarize.
Well, I'm going to close it up real fast. So, and each of those companies has a subscriber base. That subscriber base is companies that agree to provide information and have available to them information from other lenders to that same individual so that an informed decision can be made regarding the application that's submitted by that individual. Okay? That's what a subscriber report is all about.
Okay,
All right?
our next class is going to be on liability, and this is what we talk about, what makes for liability and causation, and who is liable for causing credit damage. Thank you for coming.
This has been fun, Tom. Are we done? Did we fill it up? What do we have? How much short are we? 6 minutes? Oh, we'll fill that. I'm not worried about that. When did you go mute? When did you go mute?